Good day. I'm Jenny Martin, Director of the New Hampshire Bar Association's Legal Services Program. The following video, Domestic Violence Restraining Orders, Obtaining Protection in New Hampshire through RSA 173B, is a production of the Domestic Violence Emergency, or DOVE project of the New Hampshire New Hampshire Bar Association's Pro Bono program. Funding for this video is provided by the New Hampshire Supreme Court Law Library Pro Hoc Vice Fund. Additional funding is provided by the New Hampshire Bar Foundation's IOLTA program. Please note, points of view in this publication are those of the authors and do not necessarily reflect the views of the New Hampshire Law Library Pro Hoc Vice Fund or the official position or policies of the IOLTA grants program or the New Hampshire Bar Association. Please be aware that laws do change. This information is effective for April 2015. This video is the second installment of a program series developed to assist pro se litigants who are seeking orders from New Hampshire courts in civil cases involving domestic violence. The first installment of this series, requesting child support orders from the court, is also available at your local public library. These programs are not to be taken as legal advice, but are intended to offer instruction regarding the process. We understand the challenges to obtaining legal representation, but do recommend seeking a consultation with a lawyer when possible. If you or someone you know is seeking protection from abuse, you may want to contact your local crisis center for support prior to filling out the petition. Please call the domestic violence hotline at 866-644-3574 if you need free legal assistance in a restraining order case. A volunteer with the DOVE project may be able to help. Please ask your crisis center advocate for information about how to apply for the service. I want to extend a warm welcome to our presenters today. We have Don Hebert of Hebert and Dolder in Concord, New Hampshire. Don previously served on the New Hampshire Bar Association's Board of Governors. He is currently a member of the Pro Bono Governing Policy Board, and he is a dedicated volunteer with the Pro Bono program and for our many clients. Also, we wish to welcome Elizabeth Perry of the Law Office of Katherine J. Morneau in Nashua, New Hampshire. She, too, is a very committed volunteer with the Pro Bono program, serving countless clients seeking protection from domestic abuse through our DOVE project. Really want to thank both of you for taking the time to help develop the material and to present this program today. I also want to extend appreciation to Attorney Kristen Cornell, who assisted with preparations for this program, and Pam Dodge, our DOVE coordinator, who envisioned this series and has overseen its development and production. Thank you very much.
All right, so let's get started, Dawn. So I think a good place to start, and correct me if I'm wrong, is probably to talk about what an actual domestic violence restraining order is, and kind of the statute that it falls under. RSA 173B is the legal statute that was created to protect the survivors of domestic violence from abusers. It can protect survivors by awarding what we refer to as domestic violence restraining orders. So, Don, do you want to talk a little bit about what that domestic violence restraining order is?
Sure. A domestic violence restraining order is an order issued by the court in a civil proceeding. This is not a criminal proceeding, although there may be a related criminal proceeding. So it is a civil procedure, and it's begun by a plaintiff or a petitioner filing a form with the court setting forth the facts that would amount to the abuse that the plaintiff has suffered.
Great. So I think it's probably important to go into a little bit further about who and what this 173B protects. So to qualify for protection under 173B, you have to meet three important criteria. These three criteria are a qualifying relationship with a defendant, an immediate and present danger of abuse by defendant, and also you have to provide evidence to the court that the defendant presents a threat to your safety. And qualifying relationships can be a bunch of different things. You can have a qualifying relationship under the statute by being married. You could be divorced. You could be separated. You could have lived together at some point while in an intimate relationship. You could have a child in common or share legal rights to a child with an individual. Or you can, there's some other kind of relationships, including sometimes living together in the same household. So that's the qualifying relationship piece of it. In addition, I'll talk a little bit about abuse. That is kind of a legal word and is defined under the RSA 173B. Under that statute, abuse means assault, reckless conduct, criminal threatening, sexual assault, interference with freedom, destruction of property, unauthorized entry, so breaking and entering, and also harassment.
It's important to point out that under the statute, the conduct that is going to qualify for a domestic violence restraining order is essentially a physical criminal act. Verbal words are not enough. Often people will ask if my boyfriend is harassing me verbally, if I can get a restraining order for that, and the answer is no. The only time that words alone will allow the granting of a restraining order is when those words constitute criminal threatening. So a very serious threat that puts the person who hears the words at real fear that he or she is going to be harmed. So that's what abuse is. That's the second part. The second criteria that we need in order to obtain a restraining order. And as Liz mentioned, there is one third component that is required, and I'll let Liz explain what that is.
Thanks, Don, and that's a great point in your explanation of the abuse, that really the words in only one specific instance are enough. So in order to get the protection of a civil restraining order, you need to show that the defendant presents a threat to your safety. So what does that mean? That means you have to be in fear of the defendant. And there is a standard that you have to show this by. The standard is called preponderance of the evidence. It's a fancy legal term that just means more likely than not. You know us, we like our legal terms. And, one thing to remember is this evidence doesn't have to be physical. It can be your words, your testimony, as we would refer to it. That may be enough to get a protection order in any particular case.
It's important in regards to the threat that the threat be imminent. It can't be a threat that is too distant, either in time or in place. For example, if your boyfriend calls you from California and makes a threat, and the boyfriend isn't expected back in the state of New Hampshire, that is probably not an imminent threat. And it's important that the threat or the danger be not too distant in the past as well. It has to be something that is current in order to qualify for the restraining order.
Yeah, that's a great point, Don. And one thing I would add on top of that, though, is that, even though you do need these items that have happened up front, oftentimes there's a lot of things that have happened in the past. And so, documenting all of that in kind of your petition, which we'll get into a little bit further ahead, is an important thing to do. So kind of include it all.
Yes, thanks, Liz. That's a very good point, because often what has happened in the distant past is going to be the reason that you feel threatened now, because of things that have happened in the past. So in order to put the current events, the act, if you will, or the acts that are causing you to file the petition immediately, it is important to include the past acts that cause you to fear for your safety.
So this 173B, it provides two types of protection for individuals, and the two types are, offers a temporary restraining order, or also what we refer to as a permanent restraining order. A temporary restraining order is the initial restraining order that you get when you go to court to file for protection. The permanent restraining order is something that can last up to a year, which can then later be renewed. And there's multiple things actually that these restraining orders provide protection for. Under these court orders, which is what they are, a defendant can be required to do a number of different things, which is relinquish firearms, stay away from you a certain distance, do not contact you or any of your family members, stay away from your home, your job, your place of employment, return property to you that you may have, among other things.
Yes, the court has the authority to grant a wide range of different forms of relief, including, for example, awarding you the use of a home if you both own the home, or awarding you the use of a vehicle if you both own the vehicle. The court can issue orders in regard to visitation if there are children involved, and in regard to child support. So there is a wide range of specific areas of relief that the court may grant.
And those are available to you in both kind of the temporary and the permanent restraining order context. So something that you may not have requested at the outset of kind of your filing. If you end up going to court later, that may be a request that you submit to the court. So I'm just going to move ahead now probably to kind of how we do this. How do we file a domestic violence petition? Where do you even start with that?
The domestic violence petition is normally filed in the family court or the district court, and the petition, unlike most of the other court forms, the petition itself is not available online. You can only obtain it from the court itself. So if you feel threatened, it's important to go to the court and ask for the domestic violence restraining order petition, and the court will provide you with the two forms that you need, and Liz will talk more about those specific forms. You will fill out the forms, and the The court will then decide, and we'll talk more about this in a
Yeah.
bit, but the court will then decide whether you qualify for a restraining order. And as Liz mentioned, there's a temporary restraining order and there's a permanent restraining order. Normally, the temporary restraining order, if it's going to be granted, will be granted right there while you are in the court. And then the permanent restraining order will be granted later on if it is going to be granted. But Liz can explain more about the process.
Great. So let's start with filing the petition. The first step to getting the restraining order is to go to the court, like Don said, and get the forms that you need. As Don pointed out, they are not online. You actually have to go in person to the court. Now, court in the state of New Hampshire its hours are 8 a.m. to 4 p.m. So if you fall outside of that window, you should go to your nearest police station to get help with the process, and you may be able to get emergency orders that way. However, if you're going to court, between 8 and 4, Monday through Friday. So to get the form, you go up to the clerk's window, wherever your court is, and you kind of explain what you're looking for. You explain that you're looking for the order of protection. Someone should be able to assist you in getting you the forms that you need. We do have a copy of the petition that you should see on your screen. And essentially, this is what the form will look like that you are handed from the court. Now, these forms have to be filled out completely. They can be filled out at the courthouse. However, they do take some time, so I would, suggest you plan a couple hours for yourself to kind of be able to fill these out completely. As you can see from looking at the form that should be shown to you, is that there are various check boxes about what the relationship is, about your personal information, and then a section for you to kind of go through the facts of what has been going on and what has happened. And then on the following page, which you should be able to see, there's a place for you to ask different things of the court. What Don and I had talked about before, some different types of relief, keeping the defendant away from you, keeping the defendant from destroying property, dealing with some parenting orders, some visitation orders, so on and so forth. And there's also extra space for you to write more in your statement of facts. And lastly, on the last page, there's more space for facts. As you can see, there's a lot of space given for talking about the facts of the case, which, should be used if you need them. And if you need additional space, ask for additional pages.
I think it's very important for everyone to write down your facts, or what will become your statement of facts, before going to court. You're obviously going to be under less pressure if you can sit down at your table or a friend's table and take some time and really develop the facts and write out the facts that you will then use to complete the petition. And when you're writing out the facts, keep in mind that what you are trying to accomplish is to convince the court that you feel threatened and that there is a very good reason why you feel threatened.
Yeah, that's a great suggestion, Don. Because it does, you do need to include a lot of information in there, and the more thought you put into it, the easier it is once you're at court. Being at court can be very stressful. So after you've completed these forms and filled them out, the court will also give you an additional form, which is a defendant information sheet. It's, if you have questions about this form, you should ask the court staff about this particular form. There is some very specific information on it, dates of birth, state of birth, ethnicity, height, and weight. All of this information, the more information you have, helps the court get the protective order to the place it needs to go, which is to eventually the defendant if it's granted. So the more completely you fill that form out, the better. And certainly if you have questions on it, you should ask the court staff.
The petition, the court order, the restraining order, is enforceable by the police, and violating the restraining order is a criminal act. Part of the reason that you complete all of the information on this second form is so that the police have the information that they need to identify the defendant, so that if you complain because the defendant is violating the restraining order, the police will be able to identify the person of whom you're complaining. So it's very important to provide as much information and be as thorough as you can in describing the defendant.
So after you have completed the forms that the court staff gives to you, you will give them back to the court staff, and they then take those forms to a judge as soon as a judge is available. And the judge will then rule on your restraining order there while you are waiting at court. And there are a couple options. The restraining order can be granted. It can be denied. And if it is granted, a temporary restraining order will be issued, and a hearing will be scheduled to occur within 30 days of that date of you being at court. They should give you the hearing date at that time when you're at court. However, if they don't, you do want to make sure that the court has a good address for you and that you are constantly checking your mailbox for any communications from the court, because it is important that you attend that hearing, which will be the final hearing on your domestic violence restraining order.
And it's important to note that the defendant, who will then be served by the court will make sure that the defendant is served. Once the defendant is served, he may request what's called an expedited hearing. In that case, the hearing will be scheduled not less than 3 and not more than 5 days from the time the request is made. So it is so important, as Liz pointed out, that you check your mail and that you be able to receive mail, because it is possible that you will receive a hearing notice very quickly. And it's going to take a day or two to get to you in the mail, and it's possible that you would, have a hearing just 1 day later. So if you do not hear from the court, you are always free to call the court and ask if anything has been filed or if there is a hearing that has been scheduled.
Yeah. And we do now have the call center for the court. So there is a centralized 800 number which you may call. And, we have a copy of your petition with you so that you have what we refer to as the docket number available, and ask the court staff on that 800 number if there's any hearings scheduled or any changes or at all. It's an excellent resource, and that number is contained within the packet that you should have in front of you.
Now, many people will ask whether it's necessary to have an attorney throughout this process. And the process is designed to be available to anyone acting without an attorney. However, it is always a good idea to contact an attorney as early as possible in the process if you are able to do that. Obviously, if it's an emergency, you may not have the time or may not be able to do that, but if you have the time and you can find an attorney to assist you, even assist you with the petition, that is always a good idea.
Yeah. So, the other option that is out there, there's actually two additional options, is that that the judge may not grant your petition and does not schedule a hearing. So he has denied your request for a protective order. If that's the case, you're still able to return to the court that day or at a later date and file another petition at any time in the future. The other option is if the judge does not grant your petition, the judge may schedule a hearing on this matter. One thing in this option is you should decide if you still want to go forward and have a hearing, because in this option, the defendant will get a copy of the petition and will see the things that you have written in the petition. However, there's no order of protection issued. So that is sometimes a little bit of a kind of wary situation for people to be in. If that happens, you may withdraw your petition at the court at that time.
Yes, so it's very important to consider that option. Probably about half the time, it seems to me, the petition is denied on a temporary basis, not because the petitioner or the plaintiff is in fear of his or her for his or her own safety, but because the facts have not been sufficiently developed or explained to allow the judge to make a determination that you are genuinely in fear. So if your petition is denied, you might consider whether you have clearly set forth all of the relevant facts and explained clearly enough why you feel threatened. And if it's possible that maybe you haven't done that very well, then you can consult with someone either at one of the crisis centers, which we'll talk about a little later, or with an attorney to seek assistance with developing the facts more fully so that you would be able to obtain the restraining order.
So the last step in this process is that hearing, whether the judge grants the temporary restraining order and schedules the hearing, or whether the judge does not grant the temporary restraining order and then still schedules a hearing. And this hearing is the step before you would be issued what we refer to as the final domestic violence restraining order, which is the order that is good for 1 year. And at this hearing, there are a lot of different things that kind of happen. The most important probably is both parties are there to tell their side of the story if they want to. And you can do several different things at this hearing. You can bring witnesses to this hearing. You can bring documents, different types of evidence, medical records, pictures, police reports, and then of course you'll be bringing your own testimony, your own words about what has happened between you and the defendant. Neither you or the defendant have to have an attorney at this hearing. Certainly, as Don suggested earlier, it's a very good idea to at least consult with an attorney before attending this hearing to kind of understand what is expected of you at this hearing and what you should really be prepared for.
The most important aspect or part of this hearing is going to be your own testimony. The judge is going to want to know why you feel threatened, and you at this hearing will need to be prepared to explain that and to to make the judge or have the judge see why it is that you feel threatened, and see that fear is based on what has occurred, based on the actions of the defendant.
So, Don, when you're going to court, are there certain things that you leave at home or don't bring to the courtroom based on kind of what the court requires?
Well, I think that most important, if there are children involved, the children should not be in the courtroom. It's inappropriate to bring children to court in any case unless the court specifically requires that they be there. This will not impress the judge, and the judge may very well require that the children stay out of the courtroom. In most cases, the judges at these kinds of hearings will require that the children remain outside of the courtroom. So you shouldn't bring children. You can bring, as Liz mentioned, any documentation that you have. If you were injured, for example, and went to the hospital, you might get a report from the emergency room or from the hospital as to the extent of your injuries. If the police were called, it would be helpful if you could go to the police department that responded and ask for a copy of the police report and explain why you would like a copy of the police report. And any other physical evidence that you might have. Physical evidence meaning, something that's material, something that can be touched. And the other thing about going to court, too, is that you need to be respectful to the court, which means dressing appropriately.
Yeah, that's a very good point, Don, in terms of, that's a question that I hear a lot is, what should I be wearing to a hearing? My response to that is respectfully kind of translates as nothing that is too tight, nothing that is too baggy or too loose, nothing that is too low cut, that is too short. Black trousers and a button-down shirt is always kind of a good option there. The other thing I find too is that sometimes the courtrooms can be cold or warm, depending on which season we are in here in New Hampshire, and also which courtroom you're in. So, I like to tell people to bring a sweater that you can put on and or take off should it be too cold or warm in there. And Don, you talked about the kids, how kids, having the children there is just not a good idea. And we talked about, filing the order before. What about filing an order on behalf of the kids?
That is generally, it's not allowed. Minors are eligible for restraining orders. You don't have to be 18 in order to qualify for a restraining order. But if the minor is going to petition the court, he or she needs to do it in his or her own name. And I guess it should be pointed out, if it needs to be pointed out, that children cannot request a restraining order against their parents.
Well, that's helpful for me. And Don, you talked a little bit about who we kind of should not be bringing to the hearing. I think what I would add to that is, if there are people that have witnessed any of the incidents between yourself and the defendant, certainly those people can be brought to the hearing either by you asking them, or you can also send them a subpoena. We have included a sample subpoena in the materials for you to take a look at. But those witnesses you're gonna want people that can actually talk about what they've seen or what they've observed, not necessarily what they think is happening.
That's right, and very often the threats or the evidence of the harm that has caused you to apply for the restraining order can be seen through either text messages or emails. So if you have text messages, you are allowed to bring your phone to the court and show the judge the text messages that are alarming to you, or show the judge copies of emails that you have, and submit those into evidence. I mean, just showing them to the judge and say you'd like to submit this email to the court for the court's review. I think that that's about all that would be required.
Yeah, that's a good point. In talking about phones, one thing, when you do go to the hearing, you want to make sure that you actually put your phone on silent, particularly if you are going to be presenting some of those text messages or voicemails sometimes that are left. You don't want your phone to ring in the middle of you talking about what actually happened between you and the defendant. So, helpful pointer there.
So after the hearing, the court is either going to grant the restraining order or deny the restraining order. Typically, that will not be done in the courthouse. Usually, the judge will say that he or she will take the matter under advisement. And that means I'm going to think about it and I'm going to issue a written order. In these kinds of cases, because domestic violence cases have a priority in the court system, the orders are usually issued relatively quickly, usually within a day or two. And the final order will be issued, and that will be an order either extending the temporary order and making it now a permanent order, which will last 1 year, or denying the petition and dismissing the request for the restraining order. And as Liz mentioned, if your request is denied, that does not prevent you from seeking a second or filing a second petition, particularly if anything else happens after that time.
And one thing that is important to point out, and often the judge points this out, is that if you are waiting for a decision on a final order, the temporary restraining order remains in effect. Those conditions all still apply if it was granted in the first place, so that there's not a lapse in a protective order after you attend the final hearing.
That's right. That's a good point. And so, and what happens if the restraining order is granted? Then, as Liz mentioned, there will be certain orders issued in regard to the defendant, setting forth that the defendant can't contact you, for example, and can't come into your home. The court may award you a certain vehicle or the house. And Liz can talk more about that, and she has mentioned some of the specific orders for relief, as we call them, that may be granted. However, it's very important to remember that these are court orders against the defendant. So in that regard, it will help you be safe, but it's no guarantee. So it's still important that you do everything that you can to keep yourself safe.
Yeah, and also to dovetail off of that is that these are specifically orders against the defendant. So they're, you will not be arrested for attempting to contact the defendant. You will not, get in trouble with the police for trying to contact the defendant if there is a restraining order against the defendant. There isn't anything prohibiting your conduct and contact. It is really against the defendant.
Yes, and so that brings up the point of what happens if the defendant violates any of the terms of the restraining order. If that happens, you can immediately report it to the police, and the police will then make a determination as to whether that is in fact a violation of the restraining order. And if it is, and if you have reported it immediately, it is likely that the defendant will immediately be arrested.
Yes, and like Don said before, a good idea would be to always carry the restraining order, should you be issued a restraining order, with you at all times. Sometimes it's easier for the police to actually just look at the piece of paper you have in your hand with the judge's signature versus having to look that up in their system. And so, I would encourage you to always keep those documents on you at all times.
Yes, that's very important. And also, I think, I'm not sure that we mentioned it earlier, but when you file the petition itself, make sure you keep a copy of your original petition. Before you submit it to the court, either make a copy yourself or ask the court to make a copy for you. And you should keep a copy of all of the documents involved in the court proceeding. And it's probably a good idea to keep your original restraining order, as Liz said, with you. However, make a copy just in case you lose it so that you have a second copy. If all else fails, you should still be able to go to the court and get a copy. But it's always a good idea to, I think, keep a second copy available.
Absolutely. So Don mentioned that I would talk a little bit about some of the other orders that you can have the court grant you in a restraining order case. So the main orders that we've talked about so far, we've talked about having the defendant stay away from you and having the defendant stay away from your family members. That's probably the order that people are most familiar with. Additional orders that you could request either at the temporary, with your petition for temporary orders or at the final hearing would be for child support payments for any children you have in common. If there's a pet, you can ask for orders specifically determining what is to happen with the pet, protecting any harm from happening to the pet. You can ask, as Don stated before, for use of a particular vehicle, for the use of your home, whether that be an apartment, whether it be an actual house. And, if there is something else specific that you want, this statute is fairly broad, and so you should write it down in the section for other relief. And the judge will make a determination about whether or not he or she can give you that relief.
Yeah, sometimes, for example, the defendant may have some property of yours that you would specifically like to have returned. So you can put that under the other relief. I would like the defendant to return my cell phone or whatever it happens to be. You can ask for specific relief in the other relief category. When the court issues the orders in regard to the residence, it is very important to understand that you may be awarded exclusive use of the residence as long as it is the home of both of you. There are times when the plaintiff might live with the defendant, but it is the defendant's home. And in that case, the court cannot order that you will have exclusive use of that home because it actually belongs to the defendant.
Yeah, that's a good point. And additionally, we talked a little bit about one of the orders being what would happen if, you two share a child in common. And I'll let Don speak on that a little bit.
In the event that the plaintiff and defendant share a child in common, and that is one of the qualifying criteria, of course, for the restraining order. And in that case, the court will most likely, particularly if you request it, make orders in regard to child support and in regard to visitation. The child support seems straightforward enough. Visitation or parenting time is often a difficult and complex issue when there is a restraining order in effect, because of course the defendant has an order that prevents him or her from seeing the plaintiff, and yet you have to exchange the child, and how is that done? So There are ways that this can be accomplished, but it is obviously, it's tricky, and you might be prepared at the time of the hearing to make a specific request as to how this visitation, or in particular the exchange of the child, is going to occur. And I'm sure that Liz can talk about some ideas for making that happen.
Yeah, so I think one of the one of the resources that the state does have is we do have supervised visitation centers, and so sometimes those centers are used as a neutral place, neutral and safe place for you to do any exchanges for parenting time. But I think it is important to point out that it is very likely that the court will award parenting time or visitation to both parents. It is very unlikely, except in very extreme cases, that there is no parenting time awarded to the defendant. Now, that can be qualified by whether or not the parenting time is supervised or unsupervised, but I think that it's important to understand when you're walking into the hearing that that is probably a possibility.
That's right, and it will almost always, the orders will almost always contain provisions for parenting time or visitation, and if there has been a divorce proceeding, or if there is an ongoing divorce proceeding, and there are orders in the divorce case for visitation or parenting time, the orders in the domestic violence case will take precedence. So those will be the orders that the parties will have to follow. They take priority. The domestic violence restraining orders take priority over a regular divorce order.
Yes. So one of the questions that sometimes comes up is, what happens if you change your mind? Can you ever take back your petition? And the short answer is yes. You can change your mind at any time. You can ask the court to withdraw the petition, and if you have received a restraining order, you can ask for that restraining order to be dismissed. However, you have to go to court to do that. And if that is something you want to do, you would have to go to court and ask the court staff about how to go through that process.
Normally, after you make the request, the court is going to explain that you need to make the request in writing to the court, and normally the court will require that you attend a very short hearing in order to be allowed to dismiss the petition. The judge in that case is just going to want to be assured that you are under no pressure that is being put upon you by anyone else. The judge is going to want to make sure that this is your free choice in dismissing the petition. The materials also contain information about the various crisis centers located around the state, and they can be a wonderful source of information and support. So I would certainly encourage anyone who is experiencing domestic violence to contact the closest crisis center as soon as possible in the process, and seek their support, because they do wonderful work.
And in addition, there's also some helpful links in the materials which will provide you with some more information should you have further questions. And what I would say too is I just would like to remind everyone that what we have talked about today is current as of April of 2015, and the Supreme Court does interpret the laws differently, and things often change in the way that the laws are interpreted and also drafted and passed by our legislature. So be careful of that when you are filing your restraining order or your petition for a restraining order.
Thank you very much.
Thank you.